Reservations have been in existence in India since the British period, and it's primarily given to three groups: SC, ST and OBC, in which seats and quotas are reserved in government job openings, competitive exams or any recruitment processes, etc. Although it existed since the British period, but a constitutional backing has been given to it through Articles 15, 16 or 334. Now what are these articles? Article 15, 16 and 334. Well, Article 15 and 16 talks about the reservations in general, but Article 334 provides for the reservation for the SC/ST community in the Parliament and the state governments for a period of 70 years from the year in which our constitution was drafted and enforced. So, last year in 2020, this particular 70 years period was expired. So our parliament passed the 104th Amendment Act, in which this 70 years period was extended for another 10 years. Do you know that the first ever amendment made to our Indian Constitution also provided for the advancement of the socially and economically backward classes, SCs and STs?
So no matter which party was in power, they have always tried to come up with some of the other provisions relating to providing reservation to scheduled castes, scheduled tribes and the OBCs. Some of the notable changes were the formation of Mandal Commission, and after that we saw the famous case of Indira Sainis. And after this, we have seen that the central government also provided the reservation to socially and educationally backward classes in the education institution also. And more recently, we have seen the quotas that were provided to the economically weaker section of the society along with the Maratha community, which was of course overturned by the Supreme Court. But in this video, we are looking at the recent hot topic, that is the 127th Amendment Bill. And in this video, we are going to discuss about some of the questions relating to it. So let's start our discussion with the first question, which is very basic, which is why do we call it an amendment bill and what are the objectives of this bill? This bill introduces the 127th Amendment to the Constitution. Now here let's understand the difference between an amendment bill and an amendment act. An amendment bill is just a proposed draft of the amendment. This is put on the table of both houses of the parliament, that is Lok Sabha and Rajya Sabha, by a member of parliament. Now this draft or bill to become an act has to be approved by both houses of the parliament and assented by the president or approved by the president. Only after which a bill becomes an act and comes into force. So let me tell you that currently this is 127th Amendment Bill because this has been passed by both houses of the parliament, that is on 9th August by the Lok Sabha and on 10th of August by the Rajya Sabha, but is still awaiting the President's approval. And only after President's approval, it would become the 105th Amendment of the Constitution. Now again a question, why is it a 105th Amendment of the Constitution? So understand this. This is the 127th time that an amendment has been proposed for the Constitution. And when it will be approved by both houses of the parliament and assented by the president, only then it will come to the force and it would be the 105th Amendment of the Constitution, which has been approved by Parliament and the President. Objectives of the bill. See, the objective of this bill is to reinstate the power of the states to prepare the list of socially and educationally backward classes, that is OBCs. Now this was snatched away from the states through the 102nd Amendment that was brought in the year 2018, and after which only the central government and the parliament had the power to prepare the list of socially and educationally backward classes. But with this amendment, the states will also be able to prepare the list and provide for subsequent reservations.
Moving on to 102nd Amendment. Our Indian Constitution does not refer the word OBC. OBCs are referred as socially and educationally backward classes by our Indian Constitution. Do you know that in India, the reservation for OBC category people is 27%? This is because the Mandal Commission in 1992, via its report, recommended 27% reservation for the OBC category based on the 1931 census. Now you might be thinking why they considered 1931 census in 1992. Well, we will be discussing this ahead in our lecture when I'll teach you caste-based census. So when I combine this 27% reservation for OBC with reservation for SC and ST category, then the total reservation becomes 49.5% or 50% depending upon the type of employment or recruitments and open competitions. But 50% ceiling is not exceeded, which is passed in the Indra Sahni's judgment that in any case of reservation, 50% cap must not be exceeded. Previously, the state governments were having the power to identify that which class and community must be added in the list of OBC. But when this 102nd amendment came in 2018, this amendment took away the power of the state governments and empowered the center and the president to identify that which class and community will be added in the OBC's list. So the power rests upon the center and the president that which class or community has to be included or deleted from the OBC's list. And also that this 102nd amendment not only provided for the center's and president's power, but it also stated that the NCBC, which is National Commission for Backward Classes, this commission will also be considered or will also be given a constitutional status, which means that the NCBC was set up in the year 1993 by the National Commission for Backward Classes Act. But this particular amendment gave this body a constitutional status, which means that now it would have been considered or it will be considered to have been established under the Indian Constitution and not under the NCBC Act. So these were the two major amendments that were brought by this 102nd Amendment Act. Now we will discuss that what all are the articles that has been inserted with the help of this 102nd Amendment Act. So there are basically two important articles that has been inserted by this 102nd Amendment Act. Out of the two articles, the first article inserted by the 102nd Amendment Act is Article 338B. This particular 338B provides for the establishment, powers, duties and structure of the National Commission for Backward Classes. And this 102nd Amendment gave this National Commission for Backward Classes a constitutional status, which means now it will be considered that this particular commission is established under the Indian Constitution only. So moving on to the powers of the National Commission for Backward Classes. But before this, also remember one thing, that chairperson, vice chairperson and 3 other members, making it a total of 5, all of them sits inside the National Commission for Backward Classes. And the most common power of the NCBC is that it inquires upon the complaints relating to the inclusion or exclusion of any class or community into the list of backward classes. There is a list of backward classes. So what all are the classes and communities that has to be inserted in the OBC list? It is determined by the president and the central government, right? So if any inquiry has to be made with regards to the complaint regarding such inclusion or exclusion, then it is conducted by the NCBC only. Now the first power here is that the National Commission for Backward Classes investigate the matters relating to the safeguards of the socially and educationally backward classes. So this particular article deals with the socially and educationally backward class only. Next is that the NCBC inquires upon the complaints regarding the infringement or violation of the rights and safeguards of these socially and educationally backward class. Next power is that the National Commission advises on the socio-economic development of these socially and educationally backward classes. Following is that the National Commission for Backward Class has to submit a report annually to the President about the working of these safeguards for the protection and welfare of these socially and educationally backward classes. Next is that the NCBC has been given this power to make recommendation to the central government and the state government, saying that what all are the measures that you need to take for the effective implementation of these safeguards for the protection and welfare of the socially and educationally backward class. Last is any other function can be performed by this National Commission as it deems fit for the protection and the welfare of the SEBCs. So this was all about Article 338B. Now we will move on to the second article that has been inserted by our 102nd Amendment Act. Article 342A. This is the second article included by this 102nd Amendment Act. This article simply states that which class or which community has to be included in the list of OBC, that is decided only by the President of India. And the central government has been given this power that whatever names has to be added or has to be subtracted, that is to be determined by the Parliament only. So the President and the central government is the decision-making authority that which class or community has to be included or excluded from the list of OBC, which means that the power has been taken away from the state government, because now the state government will have no power to include the class and community into the list of OBC, due to which a protest was done, stating that the state governments were alleging this fact that the amendment has taken our power by way of giving this power to the central government and the President to determine that what all be the classes, communities to be included in the list of OBC.
And now let's move to the next question, which is why was this bill introduced and what is the Maratha judgment? So to answer that, see, when the 102nd Amendment in the year 2018 was introduced, it only gave the power to the center to make the list of socially and educationally backward classes. And because of this, there was huge disparity in providing the reservation, because some of the people or classes of people were under the state list registered as OBCs, and there were some other people under the center's list. So you can see the disparity here, because the reservation can only be provided to the people under the central list after the 102nd Amendment, right? So this was the disparity in this particular amendment. Now, what was the Maratha reservation case? See, in the year 2019 itself, the Maharashtra government decided to give a 16% quota to the Maratha community. Now, this was challenged in the same year in the Honorable Supreme Court, and the Honorable Supreme Court said that if this reservation is provided, then the 1992 landmark judgment of Indra Saini, where the Honorable Supreme Court only decided that there would be a 50% cap, meaning that the reservation cannot exceed the cap of 50%, would be violated. And subsequently, it scrapped the quota that was provided by the Maharashtra government to the Maratha community, and it said that the center only had the power to prepare the list of the OBC, and because the 102nd Amendment was in place, the states were not given the power to make such list and provide for the reservation. Now, this 127th Amendment bill is in place to bypass that judgment and reinstate the power of the state to make the list and provide for subsequent reservation to the people under the state list.
Ahead in this discussion regarding the socially and educationally backward classes and OBC bill, you should also be aware about the Kaka Kalelkar committee and the Mandal commission. So after the enforcement of the Constitution of India, the President of India, in exercise of power under Article 340, appointed a commission, which is the Kaka Kalelkar Commission, to investigate the conditions of all socially and educationally backward classes. This commission was the first national commission for backward classes, and as per the report of the Kalelkar committee, the Marathas were a dominant ruler in most parts of the Maharashtra, and therefore it did not consider them as backward class community. This committee also recommended 27% reservation for these socially and educationally backward classes, but their report was never considered. Later on, Second National Commission for Backward Classes was appointed, which is popularly known as the Mandal Commission. The report of this commission was the stepping stone for 27% reservation for the OBC category. How the central and the state governments going to decide that how much reservation seats must be allotted to the SC, ST or OBC category? What is the population of India? How many are ST and how many are SCs? How many people migrated from India or migrated to India? What is the fertility and mortality rates and so on? So how are you going to determine about all these demographic and socio-cultural data? Through census. So census helps us determining all the answers of these questions. Census is conducted after every 10 years. Last time it was conducted in the year 2011, which was our country's 15th national census. Now, since 1951 to until date, the census is typically based upon the population of SC, ST and other factors that I explained to you. But our census didn't consider any population estimate regarding any other caste. So, since 1951 till until date, only the population of SC and ST are calculated, not of any other caste or OBC. This is why it becomes so difficult for us to estimate that how much population of our country is OBC and various groups that falls under the OBC category. So, in the year 1931, it was the last time that caste-based census was published. So, until 1931, caste-based census was there. In the year 1941, caste-based census was taken, but it was not published. And from 1951 till until date, we are not recording any estimate with regards to the population of OBC category or any other caste except for SC and ST. Also, that basically this caste-based census, it has been in news. Why so? Because the National Commission for Backward Classes is demanding for it. And the reason that the NCBC is demanding for it is that so that the states would be able to estimate that how much population in their respective territory belongs from this OBC category so that they can recognize them and accordingly reservations can be made. And also that one of the Home Minister of State, they stated that government need not have to adopt this caste-based census. So where there is a neglect or where there is a reluctancy to accept this caste-based census, there is also NCBC who is urging the government to bring this caste-based census into roll. Do you remember I told you that the Mandal Commission based on the 1931 census passed a report in which it demanded 27% reservation for the OBC category people. This was because of the 1931 census, which was the last year when caste-based census was taken, because from 1951 to until date no caste-based census is ever taken. Only the population of SC and STs were communicated or were collected.
And now let's move on to a very interesting question, which is why was the opposition in support of this bill? Because amidst this monsoon session which commenced from 19th of July, we have seen what a debacle the opposition has caused in the parliament by protesting against the farm laws, the Pegasus snooping case and not letting the parliament to function properly. But to our surprise, we see that there was a full house support in favor of this bill. Now, the obvious question is why? The reason to this is very simple. See, every political party wants to please their voter. And because we have elections coming up in the year 2022 in some of the states and OBCs form a substantial vote percentage, no political party would want to be seen as against these people of the society. Right? And believe it or not, in India, the politics has always been around the reservation. And because of this, no political party would want to be portrayed as opposed to this section of the society. Now, to support my contentions, let's start with the timeline of the events of how political parties have supported reservations in India. In 1950, Constitution of India was adopted and reservation was provided under the Constitution to the scheduled caste and scheduled tribes already mentioned under Article 15, 16, 330, 332, 334, 342 and 366. And after this subsequent year, in 1951, the first major amendment was made to the Indian Constitution, which provided reservations in educational institution to scheduled caste and scheduled tribes, and this was done after the case of State of Madras versus Champakam Dorai Rajan. After this, in the year 1953, Backward Class Commission was set up under the Kaka, Kalelkar to identify OBCs. However, it failed to make any impact. After this, in the year 1963, in the case of M.R. Balaji versus State of Mysore, the Supreme Court ruled that total reservation could not exceed 50%. Now, after this, in the year 1978, Mandal Commission was set up to consider quota for the disadvantaged caste. It proposed reserving 27% of the seats for OBCs. In 1989, the then Prime Minister VP Singh announces implementation of the Mandal Commission report, which was met with widespread resistance. After that, in the year 1992, the famous Indra Saini's judgment, where the apex court held that 27% reservation for OBCs subject to the exclusion of creamy layer. The proposal was accepted in the year 1993. After that, we move on to the year 2006, where the 93rd Amendment Act came into effect, empowering the state to make special provisions for socially and educationally backward classes and SCs, STs in admission to educational institution. And in the same year itself, 2006, a petition was filed and a case was registered in the name of Ashok Kumar Thakur versus Union of India, which challenged the Reservation and Admission Act 2006, which provided reservation to the SC, STs and OBCs in Central Educational Institution. After that, in the year 2008, the Supreme Court upheld the validity of the Central Educational Institution reservation in the Admission Act 2006 in providing 27% quota to OBC in the educational institution. After that, in the year 2018, 102nd Amendment, the National Commission for Backward Classes was given the constitutional recognition, and it took away the powers of the state government to prepare list of the socially and educationally backward classes. In 2019, we saw that 10% quota for economically weaker section of the society was provided by the 103rd Amendment of the Constitution. In the same year, the state of Maharashtra also provided 16% reservation to Maratha community in higher education and public employment under the Socially and Educationally Backward Class Act 2018. And again in 2019, we saw the case of Jai Shri Lakshman Rao Patil versus Union of India, which was the challenge to the Maratha reservation that was given. Now, in the subsequent year of 2020, we saw the case of Mukesh Kumar versus State of Uttarakhand, where the Supreme Court stated that the state government is not bound to provide reservation in promotions to public appointment or post, and no fundamental right can be claimed for reservation in promotion. Now, in the year 2021, the Supreme Court held against the decision of the Maratha reservation and has scrapped the 16% reservation quota granted to Maratha community. In the same year, during the monsoon session in 2021, the 127th Amendment Bill was introduced in the Parliament and has now become an official act, which will now be called as the 105th Amendment Act of the Constitution, which will reinstate the power of the states to prepare the list of socially and educationally backward classes.